I would just like to welcome you to this privacy event. The goal of this event is to really educate and inform people about this, the issues regarding the Fourth Amendment and the erosion of the protections that it offers, and specifically regard to the third-party doctrine, which many people have not really heard anything about and don't know that it's affecting them and their rights. And I did I even introduce myself?
No, you did not.
My name is Joshua Culla. I'm a state rep from Fremont, Danville, and Brentwood, and I, with some support, proposed some legislation that is going to be heard tomorrow at the State House. It's a constitutional amendment which is trying to address the issue that we were talking about here today, and some experts on this subject were already going to testify to the state in the state committee tomorrow, and I wanted to open up the discussion to people that might not be able to make it, or to have a more conducive conversation, which is not really easily had in a committee room. You just testify and the state reps ask the questions, and you don't get to ask questions of them. So this gives an opportunity for you to ask questions, opportunity for you to, before even the legislation is heard, to be able to kind of educate yourself on the issues that may be brought up, and that gives you the opportunity, obviously, to contact your state representative if you so choose, in support of the bill or in opposition even. Obviously, I support all activism towards getting your representative informed on what you view as important issues. So I also want to thank all of these experts, Amy and Jennifer, Jack, for offering to do this, and I also want to thank the Harlan Institute for coming, and very happy to have you, and I would like to kind of just start out by giving them an opportunity to talk about some of the things that they think about this issue, the third-party doctrine, privacy rights and regulations in general, and obviously pitch whatever organization that they're a part of, and so that you can support them in any way that you can, and subscribe to their work, and et cetera, et cetera. So I guess we should get it started by inviting Amy up to start us out.
No pressure.
Yeah.
Right. To go first. Thank you to Josh Yokella for hosting this event, and more importantly, having the vision to do something very concrete about this issue, which is very important. This is an issue, I've been mostly an academic most of my life, and the theories that I've had about privacy and the way that we should treat it in the law are not things that I really envisioned being able to do something concrete about. And Josh is showing me that maybe there is something that people are quite ready for. But let's back up a minute. To motivate this, because again, you mentioned the third-party doctrine and people don't hear about it. When you say something like the third-party doctrine, people just glaze over. It sounds so arcane and weird and inaccessible. What is this about? There is nothing, I would say, well, there's a few things, but maybe there's nothing more important, right? In a free society where we have limited government, there are a number of things that are important, but I would say that what I'm going to tell you now is equally important. I'm not just biased. Government should have to obtain a warrant based on probable cause and particularized suspicion before it gains access to your private information. I think that that is a very foundational pillar of a free society, of a society with limited government. And yet, we actually have not had this protection since the 1970s in the United States. And it's thanks to the Supreme Court in a couple of cases, the Smith and the Miller cases that you may or may not have heard of, but they involved the telephone numbers that you give to your telephone company by dialing. They involve information about your personal financial transactions that you give to your bank. In those two cases in the 1970s, the Supreme Court decided that when you share that information with the companies, which they call third parties, that you no longer have and this is the terminology, you no longer have a reasonable expectation of privacy in this information. And if you don't have that expectation of privacy, the court goes on to say, there is no Fourth Amendment protection, there is no warrant requirement that applies to the information that you shared. It's no longer protected. And this has been true in our country since the 1970s. Now, in the 1970s, we did share information with the phone company, with the bank, a few other places, but we didn't see what was coming. We did not see that we would be on the internet sharing information all over the place. We did not see that every store that you walk into is going to have one of those little membership cards where every time you check out, you're giving information about yourself. We didn't see that the credit card companies would also be tracking your spending habits and things like this. That all this information you're sharing it's been kind of exploding since the 1970s. We are sharing information multiple times a day, every day, just as a part of living our lives, getting better discounts on the things that we love, getting suggestions for the next music that we're going to like on YouTube, getting suggestions about who we might like to have as friends on Facebook, etc., etc. All of the things that enrich our lives involve us sharing information with what the government calls third parties. And all that information then comes under the third-party doctrine. So as it stands right now, all this sharing that you do makes you more and more vulnerable to government obtaining that information about you without a warrant. And when did most of us become aware of the breadth of this problem and that it was a real problem? When did you become aware of it? Anybody? Snowden, right? And Snowden was back in 2013, Snowden revelations. We learned that our government engaged in bulk data collection, bulk surveillance activities. And that was really the first time that we learned the significance of what the Supreme Court, I argue, set in motion back in the 1970s. I argue that what they did was a mistake. Now, why is this? And did the third-party doctrine start in the 1970s? Everybody talks as if it did, but actually it didn't. Does anybody know when the third-party doctrine actually came about? And in what context? Besides Jen. Jennifer probably knows. It's interesting because not last year, I keep thinking we're not into 2020 yet. I've got 2020 down yet. In 2018, Supreme Court decided United States versus Carpenter, Carpenter versus United States, and in the opinions, in the series of opinions, the justices acted, and Gorsuch mentioned in particular, that the history of this doctrine started in the 1970s. But really what happened in the 1970s was an unjustified extension of the third-party doctrine. The third-party doctrine arose in a context in which it made very much sense. They were called the secret agent cases back in the 1920s, and the kind of case you can think of is, imagine Tony Soprano. He's in his basement, and he's talking to one of his co-conspirators, and they're planning a hit or some other illegal thing. And you know how they do it, right? They've got the washing machine running really loud and stuff so that if it's bugged, nobody can hear them and everything, right? So they're making their arrangements. And part of the arrangement that they're making is that they're going to keep everything that they're discussing private, right? But then what happens if that co-conspirator turns government informant and becomes himself a government agent and turns the information over to the government. The question is, does the government need to have a warrant before it has access to that information that Tony Soprano is sharing? And lo and behold, we had this doctrine, they called it the third party doctrine, and they said no. They said once Tony Soprano shares information with the third party as co-conspirator, then the government can access that without a warrant. There is no search within the meaning of the Fourth Amendment. That's how it started. Does it seem to make sense to you in that context? Do you think that Tony Soprano had a reasonable expectation of privacy when he's sharing there with his co-conspirator about their plans to pull off a hit job or some other illegal
Yes.
end? You think yes? You think he's got a
He
reasonable
hasn't been
expectation?
convicted of a crime yet.
He hasn't been convicted of a crime yet. So then the question is, was a right of Soprano's violated by that fellow
Yes.
co-conspirator? And if so, what? Which right of Soprano
The
was
Fourth
violated?
Amendment, privacy, and
Okay.
reasonable search and seizures, yeah.
But at that point, the co-conspirator is somebody that he's basically making a contractual arrangement with, right?
But he's not been convicted.
True, he's not been convicted, that's right, that's true. But does he have to be convicted for us to question whether a right has been violated? This is where it starts to get
Yeah, that's
interesting.
where it gets murky.
This is where, yeah, and
But the right has been violated, so
Yeah.
because they should not have been doing spying on him because he had never been convicted or reasonably.
well, and see, and so what we want to do is we want to separate now the fact that this is he's become a government agent, right? This guy has turned informant, he's ratting on Soprano. Think about what he is there. He's making a contractual arrangement. In the normal case, what would you say that co-conspirator has done if he reveals information that he has promised to keep secret as part of this arrangement? What has he done? In legal terms, anybody can say what it is.
Breach of contract.
Breach of
Yeah.
contract normally, right?
Yeah.
And so then the question is, would that co-conspirator turned informant be held liable for breach of contract at common law?
No.
No.
Probably
Now, why not?
Because
Why
he's-
not?
Because he's working with the government. I mean, but,
No,
No?
that's not the reason
Okay.
why. And no,
Okay.
that's not the reason why. And this is where it gets really interesting. And this is where the particular language in the bill that we're talking about tomorrow comes about. When I was going to law school and thinking about this issue, I was exposed to the work of a scholar named Akil Amar. And Akil Amar had a book called Fourth Amendment First Principles. I believe that's what it was called. Anyway, years ago, I helped to write an interview with him, and I scoured this book, and I love this book. So Akil Amar talked about the way that we used to think about the Fourth Amendment. When we used to think about the Fourth Amendment, we didn't think, oh, did you get a warrant, or was it a proper search? And if it wasn't a proper search, we're going to exclude the evidence from the court. The exclusionary rule did not exist. Not until the 1960s, right? So what did they used to think about? They used to think about trespass. So they wouldn't exclude evidence that was obtained without a warrant. They would allow it in, but at the same time, there would be a case against the police officer who went in and searched the premises without a warrant, a case against the officer or the police department, the government, for trespass. You would have a claim in trespass. So think about that common law foundation and how it still holds criminals accountable, but at the same time puts limitations on the proper actions of government, at least, lays out some consequences that will take place. So let's go now to, modern day, where when government is searching our stuff, it's, getting information from Facebook or getting information from Apple, these other companies, and they're not searching our houses, they're not committing trespass, but maybe what they're doing is they are inducing breaches of contract with Facebook, Apple, our banks, if we want to get our cell phone companies, etc. So, go back to the Tony Soprano case, right, again. Is there a breach of contract that would be cognizable in the law? And the common law says no, actually. And again, it's not because it's a government agent. It's because the contract that Soprano is making with this co-conspirator is what was known in the common law as illegal contract. And I mean, today, actually, we know intuitively that illegal contracts are not enforceable, that you have no remedy in breach of contract if somebody breaches your illegal contract. Why is it that drug deals can only be enforced by violence, right? Because drug dealers cannot go into a court of law and say, oh, you know, this so-and-so guy breached my contract for the cocaine and he didn't give me my money or whatever. Illegal contract, right? I submit that the true basis for the secret agent cases that were the root of the third-party doctrine, the true basis for it in the common law was the fact that all of those conspirators were involved in an illegal contract, that breaking the agreement, the side agreement to keep things private, was not an enforceable breach of contract. It couldn't have been enforced. There was no right violated of those people. So of course you didn't have to have a warrant, because you weren't violating anybody's rights, no rights that would have been recognized or enforced in a court of law. Okay, so this is how the doctrine came about. The doctrine did not come about in the 1970s. The doctrine came about decades earlier, and for decades had applied only in this criminal context. But you know, from the very beginning, when the Supreme Court first recognized the doctrine, it did not name that context as the reason that, say, Tony Soprano's expectation wasn't reasonable. It just went unstated. It's you shared it, you no longer have an expectation. And that, you know, decades later in the 70s, when the court transported the doctrine from that criminal context, which was White, I believe was the last case, before they did this, they go into Miller next in the banking case. They say very little to justify how they can transport it from the criminal conspiracy context to the context in which ordinary, innocent citizens, you and me, are going to the bank or the phone company and just trying to get phone service or be able to put my money in the bank so that it can earn interest and I can write checks and have financial transactions. We are not criminals. Anyway, that is the problem of third-party doctrine, that the Supreme Court took it from the criminal context into the non-criminal context without any justification. In the 1970s, we didn't really realize the ramifications. Come 2013 and the Snowden revelations, we realized the ramifications of this doctrine, and now people have been on the path trying to do something about it. Finally, in 2018, we've seen the Supreme Court do something about it in Carpenter, but that was a very narrow ruling, and it creates a lot of uncertainty, as Jennifer talks about in her testimony for tomorrow. And then, in addition, some states have been doing things about the doctrine as well, but what I argue is Utah, for example, in passing the legislation that they did last year, they are going too broad. They are getting rid of the doctrine entirely without recognizing that at the very origins of the doctrine, they were protecting a legitimate law enforcement activity with the doctrine. I think they might have been doing it in the wrong way, but there was something there. So if Utah gets rid of the third-party doctrine entirely, and a case comes up in which, for example, you have a Telegram group, and all of these scumbags are in this Telegram group sharing child pornography with each other, say. And they have this arrangement, you know, I'll swap my child pornography and you swap yours, and they're sharing it. What happens if one in that group decides to go ahead and turn government informant, or suppose a government informant or government agent ends up being invited to that group and gets all the information without a warrant? What is Utah going to do? Is Utah going to try to fit that in under their imminent threat exemption or not? I don't think there's an imminent threat to anybody because of the child pornography that's being shared by the scumbags in this group, and yet it seems that this should fall under some sort of exception. They don't have in the Utah legislation an exception that fits that. What fits that is to recognize that they're engaged in an illegal scheme. So for me, I would think the answer to this, you can go one of two ways. You can, like Utah, get rid of the third-party doctrine entirely. Also, some, you know, in litigation, some judges have tried to get rid of the doctrine entirely. If you do that, I think you need to recognize that in its original scope, it protected legitimate activities of law enforcement, and you need to recognize that the way to do that is that no warrant is required in those cases, because in those cases, there was an illegal contract that was made between the participants. That's one direction. The other direction would be to say, we're going to keep the existing legal apparatus that discusses these things in terms of reasonable expectation of privacy, and then you'll just recognize that criminals in their criminal endeavors don't have a reasonable expectation of privacy. We can just give a little hat tip to the common law and not, you know, kind of upset the entire legal apparatus that's been around for decades. And I think that's what we try to do in the CACR15, right? Where you just use the language saying that we're going to protect information so long as it is shared as part of a legally enforceable contract. And then you're excluding a contract that isn't legally enforceable, namely an illegal contract. So I'm sorry, I went on too long. This is a very complex topic, but I'm hoping that maybe some people learned something about this that they didn't know before, and I hope I made it clear, and if I didn't, I'm open to questions afterwards. So, do you have a quick clarification question?
Yeah, I was just wondering, other than Utah, what other states or how many have adopted this, not just gotten rid of it?
In terms of just getting rid of it via legislation, I know only of Utah. I know that there are other states in which there's been litigation discussing this, but they all discuss it in the sort of reasonable expectation of privacy framework without looking at this route that I identify in illegal contract. That's as far as I know. But I'm going to let Jennifer correct me on that if I'm wrong.
Thank you.
Thank you, everyone, and thank you for coming out on this chilly New Hampshire evening. I appreciate y'all taking the time to learn about what I think is a very exciting topic. My name is Jennifer Huddleston, and I'm a research fellow at the Mercatus Center at George Mason University, which is located in Arlington, Virginia, right outside of Washington, D.C. And my research, broadly speaking, focuses on the intersection of law and technology. And I spend a lot of my time talking about data privacy issues these days. It's all over the news, and it's all over a lot of different policy areas as well. So I'm tonight just going to give you kind of a 30,000-foot look at what's going on in data privacy on the policy front, why that matters, and how the states can fit into that in both a positive way and a negative way. So starting about a year and a half or 2 years ago, we started to see a lot more conversations around data privacy as a general concept of whether or not the U.S. approach to privacy was still the one to continue on. And when we talk about data privacy, we talk about a lot of issues at the same time. We talk about people who may have concerns about data collection or the use of metadata by private companies. We also talk about issues like the third-party doctrine and government access to data. Sometimes we use the term data privacy when really what we're talking about are data breaches. People are concerned about things like Equifax or Target or Marriott. And sometimes we use the term data privacy when really we're talking about data security, of what are the best practices, how can technology help ensure these protections. But in the general parlance of day-to-day conversation, all these things get lumped into data privacy. And some people are really concerned about this. Some people will say they're really concerned about this and then continue the same habits, but it's gotten policymakers' attention. And it also is something that has a broad range of preferences. So every one of us in this room probably have different people we share different information with. We expect different things from our bank than we do from a social media company. We expect different things from different friends, and we probably all have different settings on our phones right now. At the same time, though, under the American approach, we're allowed to have these different preferences, and we see companies responding to these different preferences. So you have some companies that have really set themselves up to be the privacy-centric alternative. So things like DuckDuckGo that really values itself as a privacy-centric alternative to a big player like Google for those people who really want that level of sensitivity. Then you have other people who really are okay with giving their data for that extra 20% off coupon at the grocery store and find that to be really beneficial. And the advantage of the American approach has been that it allows both of those approaches to exist at the same time and only addresses and provides regulation when there's a real risk of harm. In those areas where we've found that it's particularly sensitive and that we're willing to potentially make some trade-offs to innovation in exchange for a little more certainty around those areas that might have more risk of harm. Things like financial information or healthcare information. In some cases, children's information or certain other forms of data. But a little under 2 years ago now, so back in May of 2018, Europe had a new data privacy law go into effect called the General Data Protection Rule, or GDPR. And it was highly regulatory. It cost companies millions of dollars in compliance and took many years to get ready. Now, as a result, we've seen some real impact of what a heavily regulatory approach to data privacy in the sense of what consumers can do could result in. Venture capital investment is already down. We've seen companies not get off the ground, and Europe already had a harder time for innovative companies to start. There's a reason that the American approach to innovation has made America a leader, particularly when it comes to innovation technology. Additionally, though, we've seen some interesting results. And I have to tell you a little personal story about how the GDPR affected me. Because under GDPR, several American newspapers have pulled out of Europe. You now can't read the Chicago Tribune if you're on vacation in Ireland. Or you can't read the LA Times if you're in Paris today. However, so I had an op-ed published in the Chicago Tribune on January 1, and I was so excited, and I sent it to all my friends. And one of my friends was on vacation back visiting her family, and she's like, I'm sorry, I'm sure it's great, I can't read it because the Chicago Tribune's not available because it's not GDPR compliant. It's one thing when it's me and my little op-ed that I want to share with my friends. It's another thing when you think about the flow of information, because one of the great benefits of the internet has been that it allows me here in New Hampshire to read a paper from London, to read a paper from Australia. And it allows that information to flow freely. However, one of the side effects of regulation can be that that may be not worth it for some companies to have to undergo the compliance costs. At the same time, though, we've seen some states act in this regard too. Not on the issue of government access to data, but on the issue of regulating data privacy more generally on a consumer level. Most notably, the California Consumer Privacy Act. The concern here is that these laws are rarely going to be able to be kept just within their borders. In fact, we've already seen large companies like Microsoft say they're going to enforce the California rights nationwide. As a result, there's some concern, as I argue in one of my papers, that these broad-based state privacy laws, when it comes to regulating consumer data privacy with private companies, could actually be unconstitutional. In part because they impact interstate commerce under something known as the Dormant Commerce Clause. It's unlikely that the benefits to the state outweigh the negative impact that they have on these out-of-state companies. Secondly, there are certainly concerns about free speech regulation as a result of these laws. And finally, contrary to popular belief, the Wild West, the U.S. isn't a Wild West when it comes to data privacy. There are already existing regulations, particularly for these most sensitive areas of data, and state data privacy laws that are broadly facing and regulating the consumers can have an impact that would result in conflicts that make it impossible to comply with both the federal and the state law, or that create situations where these state laws conflict with one another, making it impossible for a company to operate with the same product in all 50 states. Even if they were exactly the same, there's the possibility that the New Hampshire Attorney General and the Vermont Attorney General could interpret the word sale differently, making it very difficult for a company to understand what was expected in terms of compliance under the law, and in some cases impossible to comply with both. But there's another way that states have been looking at acting in data privacy potentially, and that is following the Supreme Court case of Carpenter and looking at re-examining the third-party doctrine and the state's own restraints on its own use of data. The difference here is that this is an intrastate activity rather than an interstate activity. because it's the state restraining its own power. And in some ways, this is a very forward-looking way to go. Carpenter was a Supreme Court ruling in 2018 that concerned cell phone location information, or in other words, how your cell phone pings a tower to know where you are right now. Most people don't know that this is going on. It's a very passive act. So the fact that the law enforcement were able to obtain this without a subpoena seemed very different than an analog era where in going to the bank and handing a teller a piece of paper, I kind of knew that was going to someone something. Whether or not you fully agree that the third-party doctrine in that context ever served a purpose, it seems like a very different scenario than some of the more passive data that goes on today. So the Supreme Court said in this narrow section that the third-party doctrine doesn't apply, that there's a Fourth Amendment standard and that warrants will be necessary for this kind of data going forward. And so we saw Utah last term pass the first of its kind law and do away with the third-party doctrine for all electronic data on a state level. Now, this only applies within the state, and therefore it doesn't have that extraterritorial impact. But it provides a greater degree of certainty to both consumers and companies to know when they need to respond to government and law enforcement requests. Now we're seeing other states consider doing this in slightly different forms, and seeing the fact that it's going forward-looking rather than having that extraterritorial effect and limiting innovation. In fact, in some cases, it provides greater certainty for innovators and for consumers and for the government and law enforcement to know what that standard is when it comes to accessing this data that can be very useful at times, that can have times when there are probable cause and that this data can help solve cases, but also providing strong civil liberties protection to prevent the potential abuse of that data too. Carpenter was limited, but when you think about the way that the case went and the rationales behind it, there are a variety of cases that could come up in the near future, not only with our existing technology, but with other new exciting things that are around the corner. Things like autonomous vehicles, or things that some of us are already becoming accustomed to, like Internet of Things connected devices, whether it's your wearable Apple Watch or Fitbit or an Alexa or Google that you have on your home. These things have great benefits to consumers. And we also, though, want to make sure that there's a certainty around what the appropriate access to this information is to preserve the American tradition when it comes to the Fourth Amendment. By looking forward rather than just at the existing data technology and establishing a standard that is adaptable with changing technologies, there's a way to balance the civil liberties concerns with actually ensuring that innovation is able to continue as well. By doing this at a state level, states may be able to be a leader in technology policy and further the direction that the court is already going as established in Carpenter. So that's a little preview and kind of a 30,000-foot level of where the situation is and how it's playing out on a national level, as well as the role we're seeing different states have. I'm happy to take questions after this panel or talk after the event. My colleague Jack Shannon is going to talk a little bit about what we do at the Mercatus Center and some of the other issue areas that we cover as well.
Sure. So obviously I'm the least educated person on this panel, but I enjoyed those two discussions as much as you all did, hopefully. Thank you, Representative, for having Jennifer and I and Amy up here. As Jennifer mentioned, I'm here for the organization pitch portion of the panel. So I'll tell you a little bit about where Jennifer and I come from. So as she mentioned, the Mercatus Center at George Mason University is located in Arlington, Virginia. We're a university-based research center. We're housed at the university. We share some faculty, so a lot of our scholars, like Jennifer, will teach at George Mason University. We support a few hundred master's and PhD students in economics and a variety of other fields through grant programs and fellowships where they actually come to our organization, help produce research on economic policy, and they get paid to do it and earn their degree. So we cover a whole lot of things, everything from student education to policy initiatives like this one, in which we're helping the representative. So a few dozen PhD economists and JDs, like Jennifer, travel the country with myself, a state outreach associate, on a team of outreach associates to try to push educated and quality policymaking based on economic ideals that oftentimes are lacking in some of the state capitals. So in addition to data privacy, we cover a whole range of issues at Mercatus. We touch on healthcare policy, trade policy, immigration, technology. We do regulatory policy in all 50 states. We've been around the country talking about occupational licensing as of late. We talk about drone policy, air taxis. We run a whole gamut. She mentioned autonomous vehicles. We cover a lot of policy. As a 501c3 nonprofit, we don't lobby, we don't advocate for legislation, we don't support or oppose bills. We just try to get these folks in the room with our policymakers so they can make better informed policy. That's about all I have. If you want to give them a break during the Q&A, please feel free to ask me about the policy that we work on at Mercatus, Super Bowl predictions. I can tell you the best places to eat in some of the state capitals. Anytime you want to give them a break, let me know. I'll be happy to answer questions. That's the Mercatus Center. I'll pass around some folders with some of Jennifer's research in there, and there's brochures. Feel free to connect us with anybody in the state. Obviously, I want to do more work in Concord and try and get better policy here and in your surrounding states. So please feel free to contact me. I'd be happy to speak with any after the event. But that's Mercatus. That's where Jennifer and I come from, and we want to work here more and be connected with all of you. So thanks for being here and for listening. And with that, I'll turn it over to the representative and maybe questions for these two.
Yeah, absolutely. Thank you all for very informative talk. I want to open up a little bit to questions that people have, just kind of to start a dialogue, and then after a little while we'll just break and people can just talk about kind of the issues and what it kind of sparked in their mind, and so if just go ahead and raise your hand if you have a question, and otherwise I'm going to go to the online questions. Okay?
Well, I have a question.
Sure.
It's kind of like off the beat. All right, so all this data and all this information that's going on, is there any way in the future that people could get paid for sharing this data? I mean, one of the reasons I don't participate in a lot of these things is, you're taking my information, you're selling them to another party, I should be getting paid that. Is there any, you've got the data privacy issue, but what about that market? I'm sure this is an emerging issue that's coming out of it, and would that be impacted too? Do you have to even go farther when you got the third party, but then you got the person who bought it from the third party, so it just, adds a whole different layer to it.
So I'll answer this from kind of the broader data privacy context, and then if you want to discuss it with regards to the third-party doctrine. I see the root of that question as kind of this concept around owning your data. Yeah. I think to a lot of us who consider ourselves very free market, that can be a very attractive view of this. The problem is data doesn't really obey the traditional rules of property either. It's rarely generated by one person. Data is usually the result of interactions. So who owns that? If I post a photo and it has you in it, it's both my data because I posted it, and it's your data because you're in it, and then it's the place that I post its data, and then it's where the picture was taken into data. It very quickly becomes a very complicated whose is it even question in the first place. Then when you add the fact that a lot of the value in data comes from this kind of aggregation of the data, not from the existence of a single data point of Jennifer likes Dr.
Cats.
Pepper, or cats or whatever. It comes from a kind of bulk aggregation and everything as well. So the concept of owning your data and of a property right in data that could be easily traded as value. There was actually about a year ago, California's governor proposed a digital dividend. It's very difficult to actually translate when you actually look at the nature of what this actually is and where the value actually lies. There was an interesting article, again about a year ago, of someone who tried to be their own data broker, and it was in Wired, which is kind of a tech magazine, popular magazine. And I think at the end of the day, for all their data, they were able to get like $1.26, something like that, you know. So we all think that our data is the most valuable data there ever could be because it's ours and it's personal and it's about me. But when you actually look at what's going on, that concept doesn't necessarily as clearly translate as sometimes I think we would want it to in our just kind of, this could be a simple solution type of.
I'm not gonna talk about it specifically third-party document, because this really is just about the issues you're discussing. If people really think that their data is so valuable, then why do they give it away so cheaply, right? So you would say, you know, Facebook is giving you a service. Now, some people question the value of that service, especially when there's so many people wrong on the internet, on Facebook. And it just aggravates you to look at your feed with all the wrong politics or whatever it is. But, you know, it's ostensibly, there is a value there. You're connecting with your friends and you're seeing the cute cat pictures and the gorgeous baby pictures or whatever it is that you, so there's the value. It's a trade. And you decide, is it worth it for me to get this value from Facebook? And give them the data and put my eyes on the ads that they are putting in front of my face because of the data that I've shared with them. That's the decision for the individual to make. And I think, where Jennifer and I are in complete agreement, is that the optimal solution is to leave as many decisions as possible up to the individuals and the companies to make their own contracts. I was going to ask you a question. Is, in your view, should there be any regulations? I mean, you talked about there's different types of information, so that banking might, you know, the regulation with respect to banking information might be appropriate versus not. Where would you draw the line?
I think that you want to look at those cases where there is real legally recognizable harm. So economic harm would be one of them, and also looking at cases where there is clear deception and fraud of the consumer. So to the contract argument, if you promise me X and you don't fulfill that promise, that's unfair and deceptive trade practices. That's not even a privacy-related case. I think that in terms of regulation, we want to ground it in a question of what harm are we trying to prevent, and does this have to prevent that harm, and is that a harm that we have traditionally recognized?
But in terms of, you're not sort of philosophically opposed, say, to preventing harms versus, say, let's go to the common law and look at the traditional causes of action for tort or breach of contract or other sorts of ways to redress a harm that's done by a bank or by a Facebook or whoever.
Well, I think that's ideally where you would find those definitions of harm, and in some cases, you know, we have seen in the past where the common law needs to be codified, or there provides a certain level of clarity and certainty by codifying these common law.
Yeah, and then the question would be, do you insist that a bank jump through certain hoops in advance of having been shown to do any harm, or do you just say codify the common law, you put it in a piece of legislation, and let the banks know that if they are caught committing this sort of harm against their customers, then certain consequences will follow?
So I think that I tend to be more of the technology or data is innocent until proven guilty. So in action, we don't want to be overly precautionary unless it is necessary to prevent potentially catastrophic harm. And in this space, I'd have to think of a very particular scenario
Sure.
to define that. I'm sure there is one out there that somebody could provide. But I think that, you know, the American approach to data privacy that has focused on consumers and has focused on the FTC's enforcement under unfair and deceptive trade practices, with the exception of these few other areas, HIPAA and healthcare regulation, Fair Credit Reporting Act, Graham-Leach-Biley, COPPA when it comes to children's privacy, and there could be arguments about whether those laws go too far or not far enough. But in general, we've looked at those specific sectors or specifically vulnerable populations and addressed that rather than addressing it as a broader regulatory framework, whereas Europe has traditionally addressed it as a much broader regulatory framework. And as a result, what you've seen is there's a lot more innovation in the States when it comes to different uses of data. There's a lot more beneficial uses of data as well. I think that there's also some interesting potential trade-offs. I mentioned a little bit about the concerns about the friction between a right to privacy and data privacy and free speech. There's also some concerns about, data privacy versus data security. Oftentimes these are seen as the same issue, but actually overvaluing one can lead to trade-offs in the other, or even things of well-intentioned regulations can require additional data collection. So if you have a rule that says you cannot collect data on anyone under a certain age, or you must have deletion requirements for anyone under a certain age, well now even if you didn't need someone's birthday for your website sign up, you do, because you need to know how you classify that data.
Now see, the way that I would go with that is to say minors can't engage in legally enforceable contracts. And so this is why they cannot knowingly make transactions in which they are trading personal data about themselves for a good or a service. And so it doesn't have to be a regulation per se, but it's just a recognition of a principle in the common law that they're not capable of making that contract. When you talk about the FTC and the FTC's sort of just coming in and looking for what is the term of art that's basically fraud that someone like Facebook would engage in according to the FTC? Unfair trade practices. Unfair and deceptive trade practices, right? So that is what's going on in the case United States versus Facebook right now. And have you been following that case very much, or is that kind of not your sphere?
The Cambridge Analytica?
Right, and so now there is this consent order that is pending before the court, right? And what the FTC proposes to do as a remediation for wrongs allegedly committed by Facebook, I'm not going to take a position one way or the other, but Facebook allegedly committed these wrongs against its customers, and as a result, what the FTC proposes to do now is essentially take control of Facebook for the next 20 years, a substantial amount of management control by specifying who should be on their board of directors and in what sorts of positions and how it's supposed to operate. So there's that. And in addition, something that I think is quite alarming, and I think made possible only by the third-party doctrine, in the settlement order, if you read it, there are certain passages that appear to grant both the FTC and the DOJ warrantless access to Facebook user data. And why the DOJ? Because there is a provision very early in the settlement order that says, for purposes of this order, the DOJ can stand in the shoes of the FTC with respect to all the different powers that are granted to the FTC, including appointing certain people and things like that. So to me, that's quite alarming that you have what has been traditionally, or for a long time in our country, a government that's been more hands-off on privacy issues compared to Europe, and yet it's changing potentially in this backdoor sort of way, where the FTC says, oh, Facebook, you did this bad thing, and instead of just having them pay a fine, and preferably the fine, the $5 billion that's supposed to be paid, would be distributed to the people who are actually injured by Facebook in some manner, right? All of us, right? We should all get paid. But instead, I don't know, it's going to go in some government coffer. And at the same time, perhaps we are going to have the FTC and the DOJ get warrantless backdoor access to Facebook user data for at least the next 20 years, because that's the term that this order is going on. If they can find anything against Facebook in the next 20 years, they'll add additional time. So that is the thing that really concerns me, that we're going to get it, even if we don't have federal privacy regulation in GDPR style, that we're gonna get effectively that against a lot of the big, sort of companies in this market, because the FTC is getting their hooks in that way.
So let's talk a little bit about the FTC's actions on privacy on a federal level. There's a lot of conversation. Some people feel they are too strict of an enforcer. Some people feel that they are not strict enough. So there are plenty of people out there who have argued that the Facebook consent decree hasn't gone far enough, that somehow $5 billion is not a big number, even though it is, if I remember right, it's more than would have been available under GDPR, and that these terms somehow don't go far enough. Other people do point out that there are some serious concerns with the way the FTC has pursued data privacy cases in the past. One of those concerns is that it has effectively built a common law of consent decrees. The problem, though, is this common law of consent decrees doesn't fully resemble an actual common law legal standard like we would see in other areas, like we would see when it comes to things like the secret agent cases. Instead, it's a case of if you are an innovator and you are trying to figure out what the standard is, you're kind of piecing things together from past consent decrees, and does this look more like this or more like that, and what were the circumstances, and it's not always as clear what that standard is. Secondly is the question of these cases are usually settled by consent decree rather than taken to the court, and would they play out the same in court? There are a lot of different reasons behind the incentives on both sides for why these often settle via consent decree. And then finally, I would point out that 20 years in technology is a very long time. If you think about what technology we were all using in 1999, the conversation we'd be having, this wouldn't be being live streamed right now for sure, the conversation we'd all be having about these issues looked very different, and yet that wasn't that long ago for a lot of us. So, they're very clear. I very clearly remember my first AOL account, so it was exciting. I'm part of the generation where AIM was big, and we all got really sad when it died about a year ago. But yet, at the time, these were huge things and huge questions. And so to think about what 20 years from now data privacy may look like, what that technology may look like, would we have sat here in 1999 and predicted the rise of smartphones and mobile phones beyond just a basic, handheld device? And so it can oftentimes make it very difficult for a company that wants to improve when they have to go and ask for permission every time, or when they're subject to a consent decree that prevents technological innovation based on actions and based on potentially what could become outdated privacy and security.
I have a question. It's kind of related to this. Last couple of weeks, or maybe a month, on the news with the DOJ and FBI trying to break into one of the Apple phones. And in my mind, you'd think they could just get a warrant and have it done. I mean, obviously it can be done. People have done it before, but there seems to be this big, they want it done, Apple won't let them do it. I don't know. What's your feeling? Because it seems like it's just beta, right?
Well, so Apple doesn't want to do it.
Right.
And I hear that it can be done by other people who are more than willing to do it.
Right.
Why does the government then pursue Apple specifically?
Yeah, exactly.
I think that they would like to establish the principle that Apple cannot sell a device to which they cannot
break.
Get access, some sort of a back door.
Right.
And to me, I think this is just wrong. I mean, Apple is one of the companies, I think, that caters to the consumer's desire to maintain privacy. They market their phones as something that you can't break into, that unless you've got the code or your
Right.
fingerprint or the face recognition, whichever one you're brave enough to go with, that your phone is locked and that your data is safe in there. And so what Apple is selling you, I see it as the 21st century equivalent of a house that you own, to which, or it could be a house, it could be a chest of drawers or something, but some piece of property to which you alone have the key. And if the government wants to know what's in that, it has to present you with a warrant. I mean, imagine that, it used to be that the government would have to present the subject of the investigation with a warrant. And, you know, heaven forbid that the government should have to go back to doing that. I mean, that's just so arcane. I mean, we have technology now and
Well, in
everybody's
this case,
sharing their
that
information.
person's dead,
And so the
right?
government, well, okay, but, and this is the thing,
So
right?
that's the problem,
So,
right?
suppose, you know, now we have to, there were always keys before, right?
Yeah.
But suppose before we even have any of these devices, there are, you know, safes, there were safes. And a safe could be something to which the one person only knows how to crack that safe. And maybe if somebody tries any other way to get in the safe, it would explode or something. That would be a analog
Right.
equivalent of what we're talking about. If the person dies and the government can't get in there, does that mean that that particular type of safe is something that should be illegal to own? Just because that happens in certain, I say no. I say just as a device, you know, like that safe or our phones could be used for nefarious purposes, it has, for all of us, the protection of our private information that I think we should be entitled to unless the government has a warrant based on probable cause, based on particularized suspicion. The fact that there are these high-profile cases in the news where, I mean, there is a scumbag terrorist
Right.
and they want to get the information about the scumbag, right? That gets us all excited, but the question is, does this type of device, a fully encrypted phone, that you know your stuff is secure and that without you, nobody can get access to this, is that something that has a legitimate life-enhancing purpose for innocent, law-abiding people? And I say yes. And, I mean, we have the same argument about guns all day long. And guns are weapons. You're not gonna completely ban weapons, or at least I'm not gonna say that we should completely ban weapons because they can be used for bad purposes. So, I am completely on the side of Apple. Apple, I think, should refuse and keep standing up for our right to have the 21st century equivalent of the house or the chest or the safe or whatever, to which we alone have the key, and make the government present us with the warrant
Right, yeah, I
again.
agree.
And if we're, you know, something happened to us, then government's out of luck sometimes,
Yeah.
but they have an incentive to keep us alive now.
Exactly.
This is largely beyond the scope of my research. All I would point out with regards to this is people talk about the crypto wars. This has been a technology policy debate for a long time. It ebbs and flows. So this is just the latest resurgence of kind of this conversation about whether or not there should be required backdoors, and there's plenty of scholarship out there that that all of a sudden has become relevant again. Not that it was ever not, but it's almost exactly the same arguments that were made, what, 5-10 years ago.
Yeah.
It kind of regularly
Yeah,
comes.
when the RSA cards came out,
Right.
key codes and stuff, yeah.
So, I can't add anything to Amy's answer to your question. But as far as your question, my feeling is that I think that this industry, the technology is very new, and I am excited for all of the possibilities and people coming up with new innovative structures for how they run their business. From from one suggestion or one thought that I heard was something like a YouTube where the more value and the more likes you get, you get more essentially money to advertise that stuff. And so the more value you're giving to the people, then you get like free advertising kind of a thing. And so you're getting rewarded by people liking and you sharing good content and stuff like that. Innovative ideas like that where you're incentivizing good content to get out there, and the sky is the limit, and I think the government should stay out of the way as much as possible and do something like kind of like what we're trying to do at the State House, is just say, we're going to enforce your contracts. We're not going to tell you what those contracts are. You and those businesses come up with a great solution that works for you and go forward from there. Any other questions from inside the room? Off right now? Yeah?
Amy, have there been any recent developments, any traction that has been gained in social media companies on basically the importance of the third-party doctrine? Because it's in their self-interest to basically come out against it.
Well, so, I mean, the case that I'm following is this FTC Facebook case, because, by the way, I didn't plug my organization, I should plug, right? I have Center for the Legalization of Privacy, CLP, and you can find it at legalizeprivacy.org, legalizeprivacy.org. And what we did was file an amicus brief in this case, FTC versus Facebook. And a number of organizations have done this now. Epic was leading the way at first, and Epic also tried to intervene, and that is still pending. We're going to see whether they're going to be allowed to intervene as a party, the two parties being government and Facebook. The judge in December took the unusual step of requiring all of the amicus briefs to be answered by both parties, the FTC and Facebook. So the government and Facebook have to answer the arguments in all the amicus briefs. The briefs are due Friday for that. So Friday the 24th. And we get to see. Well, I mean, I don't know if I have a busy week. You know, again, the judge said that they are to answer all of the arguments in all the amicus briefs. I'll get to see. Have all of these high-paid government and Facebook lawyers read my brief, and will they be answering my arguments? I will be excited if they do, because, again, what I have laid out there is that the settlement order as written appears to grant warrantless access to Facebook user data, to both the FTC and the DOJ, that this is wrong, and it's wrong both according to my preferred solution to the third-party doctrine issue, but also if you analyze Carpenter, I believe if you analyze Carpenter, you would see that the type of data that's at issue here would probably fall under the same type of reasoning. So I argue both ways, because obviously I can't expect that my preferred theory is going to be accepted by this judge, right? So we argue both ways. But yeah, I get to see whether the high-paid attorneys at Facebook recognize that there is an issue here. You know, when we talk about something like CACR15, it is a restriction on government, right? It says government must obtain a warrant before getting this data. Technically, it doesn't affect private companies, and this is something that you are, in favor of. The only private company that it would affect is a private company that is not always concerned to meet its contractual agreements with its users. So for example, and I don't know enough at all about Facebook, I know nothing about Facebook. In my, the brief that I wrote, I take no position as to whether Facebook did a bad thing or if they, nothing. All I say in there is that regardless of whether you think Facebook did a bad thing, giving warrantless access to Facebook user data to FTC and DOJ for 20 years does not look like much of a remedy if the goal is to protect us, the users, right? So we don't know if FTC, we don't know if Facebook has any bad motives. But if a company was wanting to make all these agreements with users and, oh yeah, we'll keep your data private, and then they wanted to routinely just turn it over to government all the time to get special favors, say like a regulatory scheme that would give them an advantage because it would create barriers to entry for any competitor of Facebook or something like that. Those are the kind of people that would not like CACR15. But those are cronies. That's cronyism. That is not capitalism. That is not free market. That is not a truly private company. So, yeah, we're going to find out in the coming months.
That actually goes
Facebook
to our
has made
first online question, which was like, what should we be indefensible as individual citizens against undue searches and seizures because it's legal for third parties to just share that information And what we're saying is essentially that there is recourse because it's a contractual agreement. What if you're limiting that the use of that data via contract, then potentially they would have ramifications if they breach that, right?
I mean, this is where it's frustrating, right? Because, I mean, Jennifer, correct me if I'm wrong, because you will know a bit more about this, but every time I look at a contractual arrangement that I would have with one of these private companies, it's the same with your doctor, with everybody else. Yes, we protect your information that you share with us unless compelled by government, right? There's always an exception. So then the question is, will Apple or Facebook or whoever turn your information over to the government if they're presented with anything less than a warrant based on probable cause and particularized suspicion? Some companies, they like to create a reputation for protecting your privacy even against all of the types of process that they're served by government, and they'll give you stats. Apple will say, okay, we've had X number of requests for data in the last year, and we've granted this many number, and we've fought this many number, and etc. And the ones that seem to be resisting a bit more, those of us who are actually concerned about our privacy and not just pretending to be, will try to give more of our business to those companies. But until you have an actual warrant requirement, then, I mean, who's to say that a subpoena isn't enough so that they're not breaching a contract if they turn it over? A subpoena would probably be fine, right? It's not a breach of contract if you turn it over.
Currently, I think that most people, I mean, in the privacy policies that I read, they only say subpoena, like up to subpoena, because I think that going further right now because of the third-party doctrine is impossible. They
or
would
expensive at least to fight. Yeah.
Sure. I think I think this kind of the proposal is if it was passed would be able to allow people to raise their policy from just subpoena to search warrants, so the next question is, do you agree that our information on digital media is similar to our private property in our homes? And my view is it depends on if you have essentially contracted it to be continue that privacy. If you've had some, if you've tried to keep access or control of that access. If you didn't, then it seems like you just open it up to whoever wants it. But what are your thoughts on this subject?
So it's not a panel with this many lawyers unless somebody answers a question. It depends, or it's complicated, or some variation thereof. So I'm going to go with, instead of it depends, it's complicated. As we were discussing earlier with kind of the concept of owning your data, it's not as straightforward as or I would argue it's not as straightforward as an Apple phone is your home device. I think that the safe analogy is a very interesting one, and one that I'm certainly going to have to discuss with you afterwards, because I think it's a fascinating idea. But that being said, there are different environments where we expect different levels of privacy. It's a different level of privacy when you're walking down the street as an individual versus sitting in your own home versus in a semi-public situation versus if it's being live streamed right now. So it's more complicated than just a yes or no, it is or isn't the same when it's online, because there's so many nuances and specifics to be considered there, and there's so many different preferences as well in terms of how publicly accessible we want our information to be, of how much we're sharing, again, of different individual preferences, different trade-offs that we make as an individual. There are some people that are very, very concerned about their privacy, and they would rather not use a product than give up what they see as a violation of privacy. There are other people that would be perfectly happy to give you all the information on their cell phone for whatever, a free pizza or whatever. And most of us exist somewhere in between those two extremes. Most of us have different situations, and it depends on the information, what we'd be willing to pay, either in terms of taking on some friction in our interactions, or even pay in terms of an actual monetary amount to use a product that more accurately reflects our preferences, because a lot of us do see a lot of benefits to data, and even if we aren't putting it in that language, we see it in the way that we make those choices. We see it in the fact that we like, or that some of us, including myself, I prefer that I get the ads for Ann Taylor and vacations to whatever random ads might be generated in my newsfeed. Other people find that they don't like that because it triggers them to buy things, or because they feel that it's some kind of violation that a third party could know that information about them, and so there are ways to opt out. So I think ensuring that like I said, it's not always as clear cut as a analog analogy might make it.
Yes, yeah, James.
I don't know if this applies, but what I'm hearing is a sea change from when I was taught in the 60s that the laws were such that 10 crooks could go free so that one innocent person would not be convicted. But now I'm hearing that we would rather have collateral damage and have that innocent person go to jail so that we can get those 10 crooks. And I'm not sure I'm comfortable with that.
And you're hearing that with respect to what exactly?
The FTC controlling Facebook for 20 years.
Well, okay, so
And the DOJ stepping in, because quite frankly, from what I've seen of the last 3 years of the DOJ, I'm not quite sure I'm happy with them.
okay, so we'll assume for the sake of argument that Facebook has done some bad things, right?
Okay.
And so then
We
the
know they
question,
have.
yeah, well, I'm not gonna.
That's all right.
I like Facebook, and
I love it. That's
But-
how I found Josh.
Okay, regardless of whether Facebook did some bad things, then the question is, what is the proper role of government with respect to that? What should, and we could argue, we could say, well, maybe there is a role for an FTC, a Federal Trade Commission, in the sense that they are experts in identifying when a company like Facebook is engaged in unfair and deceptive trade practices, right? And they are good at tailoring appropriate remedies, etc. But who should be reimbursed? Who should get the money? Who is it that should be punished? Facebook should be punished if they did something bad. The users of Facebook should get some sort of compensation if they've been harmed. But as it stands right now, the people who maybe stand to be punished the most are all of us. One of the things that I said in the brief was that really the idea that for Facebook violating user privacy deceptively in some way, as a remedy for that they're going to give access to the government to Facebook user data for 20 years, that this would make Orwell think he's reading The Onion. And I think that's right, because how in the world is that an appropriate remedy? It just is not. So they're punishing all of us. They're taking the sort of treatment that used to be reserved to the Tony Sopranos of the world and saying by default now the government can access any data that we share with any of these companies for any purpose, any life-enriching purpose. There's so many of them these days, that they can get that without a warrant. And the only level of protection that we do have, because the warrant requirement is gone, it is at the mercy of legislators at the state or the federal level, like Josh. Now Josh is a good guy and he wants to give us a lot of data protection, right? But the next batch of legislators might not be, and in other states it's not, and the federal government, who knows if the federal government even cares about us out in the states anymore and our data protection. it should not be at the mercy of legislation. It should be protected by a constitution, by an enduring document, and we're just not there. So now it is that, yeah, the FTC might have access to our user data for 20 years, and you know the Bentham Panopticon. Do you want to explain the Panopticon to them or no?
Go ahead.
Any of us privacy geeks, we know about the Benthamite Panopticon. Jeremy Bentham, the utilitarian philosopher, designed in his spare time a prison. And the type of prison that he thought would be the most efficient is one in which you could have, I guess, a multi-level prison. Each of the floors, you've got a central room, and then you've got kind of spokes coming off of that, like spokes of a wheel on each floor. And down each hallway, there's all the different prisoners' cells. And so you could have one guard standing in the middle, and that one guard could potentially be keeping an eye on all of the prisoners all around him, you know, all 360 degrees around, 24 hours a day, constant surveillance. And what privacy geeks like us talk about all the time is that we are more and more living in the panopticon. If the FTC and the DOJ can get access to Facebook user data, in addition to all of the consumer protection data and other data that's amassed about us already under the guise of protecting us, they will. I mean, we will all be in the panopticon, and the panopticon was designed for criminals, not for all of us. So in that sense, you're right. But was it a comment of horror that you were making, or you had more of a question? Because I lost it if I got more of a question.
I was just looking for confirmation that what I'm seeing is a sea change from what I
From the
grew up
1960s,
with
yeah.
to what these people are pushing now in DOJ and FTC. I see the problem, I just don't like the solution.
So, I don't necessarily think we're as close to the panopticon. I tend to be more of an optimist. I think that there are a lot of different choices. I think there are a lot of ways data has changed our lives for the better. I think what we're seeing right now is kind of an interesting, murky transition period where there is a case of, because technology moves at a more rapid pace than policy can sometimes. Sometimes that's really good. You get a pacing benefit. If technology outpaces technology, it allows us new freedoms, it allows us new ways to empower ourselves, it kind of shows why it's needed. We don't have government regulation of it so that new things can emerge and improve our lives in certain ways. In other cases, you have a pacing problem where technology moves faster than public policy, and as a result, sometimes policies that at one point in time may have served a legitimate purpose become not necessarily outdated, but difficult to meld with existing technologies. This can happen with things like access to data, but it can also happen with things like transportation technology, of regulations related to cars. So I spend some of my other time working on transportation innovation and things like autonomous vehicles. So a safety regulation that says you must have a steering wheel in your car seems like a logical regulation to require a car must have a steering wheel, until you get to a place where there's level 5 technology, where the car doesn't need a human driver whatsoever. Then does that regulation serve a purpose? Well, if that regulation is set in stone such that it can adapt to the pace of technology, or it takes 20 years to change that regulation, it can delay the deployment of a technology that could actually end up being better than human drivers and save, thousands of lives every year. I think at times with other technologies, it's not necessarily a sea change in terms of how we look at something like whether we would rather an innocent man go to jail or 10 guilty ones go free. It can also just be this kind of friction period where courts and policymakers are trying to figure out whether or not there is some kind of underlying need for change, or whether or not the common law can adapt at a sufficient pace to not require a statutory change.
Yeah.
Caller?
Yeah, can I ask another question?
Yeah.
Okay. Minority Report.
My favorite tech policy questions begin with Minority Report, Black Mirror.
Pre-crime. I mean, you know, Google has the ability, according to Dr. Robert Epstein, of moving 15 million votes in the next presidential election. Now, clearly that's, you know, messing around with our elections. But they're also saying that they can predict stock market crashes, insurrections, they can predict, eventually, by accumulating data. When 1 million people start Googling, searching for such and such, the people at Google, their computers can predict something is about to happen. They can predict a crime that's going to happen or whatever. And how does what you're doing affect that? Aren't the two connected?
So I guess I want to add that to this this question so we can get through this question. Is really the role of government in keeping with the Constitution and Declaration of Independence to gather data? Is that the proper role of government, to gather data on its citizens? Okay. Talk about either one of them. These people talk about like that they really think that we should try to keep the American tradition of individual sovereignty and your personal privacy. But what are your thoughts?
So I'm going to kind of put them both together in part, because I joked a little bit. My favorite tech policy questions begin with Minority Report, Mr. Robot, Black Mirror, whatever. Because if you look at the news today, or if you watch any kind of film, we're only one step away from a dystopia, and you know it's going to be the next technology that pushes us over the edge, and it's going to have been the next technology that pushes us over the edge, going back to I think electricity or running water or whatever. Fire probably. Some caveman was talking about. This is the end of it. But at the end of the day, we are remarkably adaptive to technologies, and I talked about the pacing problem. Some of that is because we now accept new technologies at a faster and faster pace. And oftentimes when we look at headlines, when we look at television shows, when we look at movies like Minority Report, we're only seeing the worst case scenarios. We're seeing the dystopian, and that's not to say that that couldn't happen, but it neglects all of the benefits. And that is why it's an important balance to some degree to make sure that there are checks that ensure that civil liberties are in place, that the traditions regarding some of these foundational principles are still protected, but also that recognizes that there are times when there can be benefits to, say, the government having certain data. So I mentioned that I also work on transportation innovation issues. One of those things is on micromobility, which is my way of sounding really smart when I talk about dockless e-scooters. Because if you say you're a scholar who studies scooters, yeah, that's what happens. So there's been a lot of debate about whether or not cities should be able to get the GPS data from scooters and at what level, and you know whether or not that data should be able to be publicly released. You certainly, and systems and everything like that, you certainly can see a reason that a city having access to scooter data could be used for a very benevolent purpose. Maybe it's determining, hey, there are a lot of scooters in this one part of town, or a lot of bikes in this one part of town. Maybe that's a good place for us to start offering public transportation. Maybe we should partner with somebody to expand sidewalks or provide bike lanes there. Perfectly benevolent uses. You can also see why some people might be concerned about how that same data could be abused in the wrong situation. How that could lead to tracking where people are going, or releasing information about individuals' travel patterns or things like that. So I think it's important not to only focus on those potential abuses, but also look at the potential benefits to the individual, and in some cases, to look at the potential benefits to kind of government or cities or the population as a whole as well that can come from this. So I guess my answer is we shouldn't just look at the bad, we should also look at the good, and we should try and examine, are there cases where we need to put some kind of guardrails to prevent those abuses so that we can have more of the benefits and less of the harms.
Yeah, did you want to add anything? Or? No? Okay. So the next comment is about this flexibility in laws and how if you narrowly focus laws on the steering wheel issue, then it can become outdated. What about just focusing on the principle of the matter of I guess violation of rights or whatever, and that's going to be or we're going to respect your data if you have a contract or whatever, and would those better hold up over time, I guess, if we just focus on the principles instead of trying to get into the nitty-gritty of each individual situation?
It depends, to give the lawyer answer again. There are some cases where because of existing regulations, very specific, detailed definitions are going to be needed. There are also some cases where that level of specificity to prevent potential spillover effects on other technology or to prevent potential spillover from, say, a legitimate concern about preventing civil liberty violations from unnecessary government access could have a negative impact on private contracts because it was overly broad in its definitions or things like that. With regards to broad versus specific in terms of the technology it's addressing, that's always it depends on the specific technology policy issue. So there are times when having that forward-looking focus to say this applies to all electronic data no matter where data may go going forward can be a positive thing because it could be more adaptive. There are other times where that could be a negative for technology policy because it prevents certain innovations at other times.
Really, you know, when you're talking about regulations of the specificity that you're discussing, like you must have a steering wheel in a car. I don't, personally, for me, I would say, why should government be writing such regulation? I mean, who wants to, if a car needs a steering wheel in order to operate, I assume that the savvy consumer is not going to buy a car unless it's got a steering wheel, or if they are, they're going to realize that they have to put a steering wheel in before they can drive it, etc. And that maybe there are going to be cars someday that don't need steering wheels, and that we can all kind of make that choice for ourselves,
so
right?
you would be against selling like clocks without batteries in them because you would have to buy a battery separately.
Imagine.
Put that in.
Yeah, you mean that this is in the law
Maybe we should
now, right?
regulate that
Right.
it has to become fully operational at open box, right?
As opposed to, like, I mean, why not just use existing laws about fraud? If the packaging appears to make it
Sure.
that it's ready to go, right? Exactly. So no, I don't, laws I think should be written in a form of principle as much as possible. There are some exceptions, right? So if you have to make a decision as to what the legal age of majority is going to be in a particular state. You're going to have to be very specific about something like that. But most laws should be in a form of a principle such that they are going to, for the most part, for a long period of time, resist being outdated. And that's one of the problems that I think, we've been kind of caught, not as agile, in the law as we should be, because the laws have been too specific. That's a terrible example of automated cars. So what are they, right now, are they putting a dummy steering wheel in it just so they can comply, or what are they doing?
No, so most of the cars aren't to this point yet, but this has actually been a debate more at a state level in some cases regarding, some states have tried to have in their regulations that it must have a steering wheel. But there are going to be other cases with existing federal auto standards, particularly regarding various things of if you have a autonomous vehicle that's just a delivery vehicle, there's no passengers in the vehicle, do all these regulations that currently assume that there's at least a driver in the vehicle still come into play? And if so, and if not, so one of the great things that's been going on, I also do work on the issue of soft law. So soft law is sometimes a solution to these of providing kind of general principles and guidelines that can provide some degree of certainty for an area like autonomous vehicles where it's already regulated, not something that's unregulated right now, but regarding what regulations, what interpretations might allow for some of this more permission-less innovation and allow for some of these newer models, one-way exceptions and things like that.
This question says, what is the right to privacy in legal terms? What is the moral foundation for the protection, and where in the Constitution can we find the framework that protects it? I think that you're going to say that it's not in the Constitution.
It's in the Declaration of Independence.
Well, privacy is not listed there explicitly.
No, it says, it mentions rights that are not mentioned.
Oh, okay,
Not
so,
in-
Right, life, liberty, and pursuit of happiness, and other rights that are not mentioned. I don't know what the exact words, but that's where it,
well, this is a very abstract question, and can I give a very abstract answer?
Sure.
So I would say privacy is not a right. Privacy is a state that we can create for ourselves via the exercise of our rights. And for me, I believe a right, any right that you have is a right to take a certain action. So do a thought experiment. If you want to keep something private, this piece of information, we're not going to talk about whether we own it or not. If you want to keep a piece of information private, what is the most basic thing that you do? You have a piece of information in your head, you want to keep it private.
Don't tell anyone.
You don't, it's an omission, you don't act, there's nothing overt. A right to free speech, when you talk about what is the most basic thing that you do when you exercise a right to free speech, you have this thing in your head, and you want to exercise your right to free speech with respect to this idea in your head, you speak, you do something affirmative, you speak it out. And I think that is a kind of powerful way to think about really at what's at the root. So how do we create a state of privacy for ourselves? We either, don't say something to somebody, or if we do, right, if we do communicate that idea out in the world or put something out in the world, then we cabin it by maybe locking it in the safe or in the the treasure chest, or somewhere in our house. Draw the curtains if you don't want people to see your private things, etc. And typically today, how do we mostly try to protect our privacy? Through contractual arrangements with third-party providers. But it's a state, and we're trying still to create that state. Ayn Rand, who's a philosopher who I happen to admire quite a lot, said civilization is the progress toward a society of privacy. And yet, supposedly we've become more and more civilized and things have become less and less private. Why? Because there's been a breakdown. We are still trying to use our rights to protect states of privacy for ourselves, but our government is not allowing us to do it. We cannot create enforceable contracts to protect our privacy anymore, unfortunately. And that's the thing that I think we need to change. And I think if we eliminate cabin the third-party doctrine, we can.
So if it was in the Constitution, maybe the right to, against self-incrimination or something like that would be your right to keep some information that you want to keep private. You don't have to share it with the government.
I mean, your
the only thing in the
state
Constitution
of privacy
would be,
is protected against the government. And this is something, Steve Simpson is a great attorney who I had a discussion about this issue with. The government could do a whole lot of things wrong with respect to your privacy that aren't just, person's houses, papers, and effects. You could have, and they should be limited in various ways, not just with respect to warrants and things like that. There's certain limitations on actions of government that can affect your privacy if they don't exist anymore, and it goes beyond just a warrant requirement as well. We need to get back to the idea of a limited government where the Constitution says the government can do only these things, and that we have a cause of action against the government if it exceeds its charter of power.
apologies to the prime sponsor. Open up the hearing on CACR 15 and recognize Representative McKellar, who is my sponsor, and who has written testimony, apparently.
That's been passed around.
Yes, and it has been testified. Thank you.
Thank you, Madam Chair. And members of the committee, I'm introducing today a constitutional amendment proposed to protect from warrantless searches people's effects and property. I think that the first question that really this raises is it kind of a restatement of the constitutional amendment we just passed, Article 2B, and I submit that it is not. That the Article 2B does has kind of a fatal flaw in it that doesn't protect the things that I'm trying to protect in this constitutional amendment, which stems from what's called the third-party doctrine. It has been used for many years, and it kind of designates what is and what is not private information, private documents, et cetera, and so when we reference private information and stuff in that Article 2B constitutional amendment last time, we still have accepted that the current understanding of what is and what is not private. And so many people are not really familiar with the history of the third-party doctrine and the nitty-gritty details of that. I have asked a few experts to testify on that aspect, the history, and going into why it is the way that it is, and why this is potentially a good way to address that issue. But in a sense, the third-party doctrine is just anything that you've shared with a third party. It doesn't matter if you have contracted that information is to be kept confidential. You have no expectation of privacy, and the Fourth Amendment doesn't apply. Unless the government has sectioned off that area of things like your interactions with your lawyer or doctor, et cetera, there are certain things that it does apply to. But if you have a Google Doc, or if you have your diary stored in the cloud that isn't your own server, you've shared that information with a third party. And the government does not need to get a search warrant. They can do some lesser standard, such as a subpoena, et cetera. That doesn't necessarily even say that you committed a crime, but that information might be helpful in some prosecution. It doesn't even have to be a prosecution against you if you get that information. And so in New Hampshire, there's a couple Supreme Courts that set rulings that say stuff like our law regarding information on voluntarily exposed information to third parties is in line with the protections afforded under the Fourth Amendment. And so we haven't really differentiated ourselves from the federal interpretation, which is where this third-party doctrine comes from, whereas other states, like Arizona, have decided that our interpretation is going to be different, and or their interpretation is going to be different. And so in another case, the Supreme Court said that they were persuaded that the equities so strongly favor protection of a person's privacy interest that we should apply our own standard rather than defer to the federal provision. And so there is kind of a desire to potentially protect more than what the federal government is doing. And you are allowed to do that. The federal government is kind of putting a baseline of protection, and the states are able to increase that protection. So the final quote that I would use from a different decision is that they encourage the legislator to examine whether telephone billing records should be protected under the reach of a prosecutor's subpoena. And this, I think, all can be summed up in that there is some clarification on when you're sharing information and how and what we want to protect. And I think that that my proposal is to just protect. There's other bills that may protect other things like your DNA data, et cetera, but I am proposing that that assumes that those things are the things that you want to protect. And it is kind of designating, like the government is saying, we are going to protect these things. If you want to protect something else, that's not one of the things that's on the list. And so what I'm proposing is that we empower the people to set those terms of privacy with their businesses they do business with through a contract. They have a privacy clause in that contract, and if that business wants to offer a high level of security, which some companies like Apple and stuff are trying to create, then they would be able to protect more than they currently are able to. Right now, if you read privacy statements, they're saying that they're going to protect your information up to subpoena. And the reason why they're doing that is because they can't go further. Under the third-party doctrine, there's no protection. Really, they would have to spend large amounts of money to try and fight a subpoena and would probably still lose because of the interpretation of the third-party doctrine currently. And so what I am trying to do is say, in New Hampshire, we're going to honor your contract and say, if this company wants to just do a level of subpoena, the government's fine with that. If you want to go all the way up to a search warrant for that information and show that you have done something that could potentially be a crime before they reveal your information, then we are allowing those companies to do that. This isn't a demand of the companies. This is it actually is a restraint on government from breaching legal contracts with people like your internet service provider or any real company that you do business with, whether it be the sign-in sheet at your local gym or your Uber ride or whatever the case may be. If those companies want to offer that additional protection up to a warrant, I say I am proposing that we respect that. And I am happy to answer any questions.
Thank you very much. Representative Woodbury has a question.
Thank you, Madam Chair. I'm trying to understand something, and I guess I'm going to start with a hypothetical that means something to me, and hopefully it'll straighten me out. Let's assume I'm a thief. I go down to Atlanta and I break into the safe and I steal the secret formula for Coca-Cola, bring it back to my house. And then I talk to my friend, Representative Gordon, who's going to mix up a batch for me, and I give him the information. What's protected there? Am I protected? I've got the formula at my house.
Right.
I think I should demand a search warrant before the police come and take it away from me. But what happens to the information when it's in Representative Gordon's hands and he's getting ready to mix up a patch?
Absolutely, absolutely. There's so let's assume that you've had a contract with him saying you're not going to reveal this to anyone. That we have this stolen information and we're going to make a batch of our own. And under this rule, that contract that you have to keep that information private is what is called in the common law an illegal contract. You're not allowed to, that isn't going to be recognized by the state as a valid contract. And so him turning informant and saying that you have this and them using that as evidence to get a search warrant for your premises is completely within the bounds of this this regulation. Yeah.
A follow-up or?
Yeah, it's actually a follow-up, yeah.
No, I just want to know, Representative Woodbury had a follow-up.
I'm all set. Thank you.
Okay, then Representative Griffin.
Thank you, Madam Chair. Thank you for taking my question. In follow-up to Representative Woodbury's question, keeping in mind, of course, that I will be at Representative Gordon's house drinking the Coke because I can't stand Pepsi. What about if Representative Woodbury contacts Representative Gordon through the internet, using the cloud as the server to communicate, I am sending you this formula, and you are to keep it confidential? Does that change the transaction at all? Because now it's out there. Okay.
Because the third party is really anyone that you share that information with. And if it's an illegal contract, because the purpose of the contract is to conceal a crime, yes. If it's to conceal a crime, that is not a valid contract, and so all the provisions of it do not need to be honored.
So your answer to Attorney Woodbury was, Attorney Gordon's stuff would still be gained for purposes of investigation, because the
Right.
contract to keep it confidential was.
Right, but the contract with your service provider
Yeah.
is not an illegal contract, you're just trying to get service, right?
Right, so.
And so that would be protected, but
Exactly.
not the protection for Gordon.
Right, but I think I think you've clarified my answer.
Okay.
Thank you. Thank you very much. Are there any other questions? Yes, Representative Birch has a question.
Trying to figure, I know that third-party doctrine is highly debated these days. And the Supreme Court, either in the Carpenter case or otherwise, has been. So, let's say you've written out a confession to a crime, and you send it to me. Are you and I have it on my desk, and we send it to you. Are you suggesting that you still have some expectation of privacy after you've mailed it, such that the police will have to get a warrant to protect your privacy from taking it off my desk?
So what I'm trying to do is protect the contract. And so if you're saying that you gave this confession, let's say, and you said I didn't want you to release it until I've had my lawyers edit it or something like that. And so you're contractually obligated to not release that information, right? And I'm still keeping.
Go ahead.
So if I just give it to you with no conditions, then there is no contract to keep it secure. So if you read the language of my bill, it says a legally enforceable contract in which you limit that the information is to be used for only a limited purpose and otherwise to be kept confidential, right? And so if I gave it to you and I didn't demand that you keep it confidential for any reason, and the condition on me giving you that information was not that you gave it confidentially. So that is, I believe that case is not, I think, I am not a lawyer, so I would have, there's a couple of lawyers behind me that would be able to better answer whether or not they believe that that was an illegal contract. Personally, I don't think it's an illegal contract because it's not in the commission of a crime, or the purpose isn't part of a crime. But I also think that in your question, you didn't have a contract in which it limited the giving of the information to the police in any situation. So.
Representative Wilbur has a question.
Thank you. So if I'm understanding this properly, what you're proposing only applies to things that meet the formal definition of a contract. That there's such things as consideration and specific wording protecting privacy. Is that correct?
Contract is in the language of my amendment. So I would be only protecting what is considered a contract. Now, you can have a verbal contract with someone, right? Doesn't have to be written and notarized by people. So any legally enforceable contract would be protected.
I think you need an oral contract,
Sure.
since verbal is using words which could be spoken or written, whereas oral is unspoken.
Thank you, Madam Chair.
I just want to make sure that we're clear on what we mean. Are there any other, yes, Representative Harper has a question.
Thank you, Madam Chair. A lot of times we pass constitutional amendments, then use the RSAs to define them or to clarify them. Why aren't you just clarifying our right to privacy and implementing this as a House bill instead of an amendment, which the hurdle to get that through is pretty ridiculous?
So I believe that the protections are, a little bit, there is a significant amount of additional protections by having it as a constitutional amendment, in that it can be edited and changed as easily, and so it's really a commitment. But also, I think it opens is going to make the. I think that it's going to really make it clear that we disregard the interpretation of the federal constitutions, and that it wouldn't supersede. Because if you said, okay, we have this RSA, maybe it's unconstitutional because of the current interpretation of the Constitution, right? And so you would have to change the interpretation of the Constitution to make that honoring of that contract constitutional. Is my feeling that it's possible that it would be considered unconstitutional based on the current interpretation of our Constitution, and that it's kind of risky that the Supreme Court would interpret it the way that we intended it to be interpreted. I think. Thank you. Absolutely.
Thank you very much for all the time. And Representative Gordon, question. How's the Coca-Cola? How's the Coca-Cola?
How's the Coca-Cola? It's great.
He's a Pepsi drinker.
The current law is that if you basically share information with a third party. It doesn't have constitutional protections, our constitutional authorities. The problem I'm having is with the language, because it says, including information provided as part of a legally enforceable contract. So, provided seems to indicate that it's in exchange for something, or information requested, as opposed to simply shared. And it would seem that if I wanted to go beyond constitutional protections, that I would want to say, including information shared with a third party as part of a legal enforceable contract, which would get to the heart of the issue.
Representative Deere, I know you have some,
Yeah,
some people who are following.
Yes.
If you feel uncomfortable
I
answering, you
am
don't
not,
have to.
I'm not necessarily uncomfortable with the change, but I kind of would have to think about the definitions of these words and really kind of dig into what the ramifications of that change would be. And so I would definitely ask that some of the experts would weigh in on that.
I'll wait my turn.
Any other questions? I don't see any. Thank you very much for
Thank you.
taking the time to explain this to us. The chair recognizes Robert Davis, who is from Illinois. Welcome to New Hampshire, and representing the Heartland Institute. Stay around, we have a presidential primary, and it's very interesting.
Madam Chair, members of the committee, thank you for taking the time today. I know I'm with the Heartland Institute, and we're looking today to ask you to consider supporting CACR15, the amendment to the state constitution that would protect the privacy rights of New Hampshire citizens from unreasonable government searches, as well as seizure of their electronic data residing specifically with contracted third parties. As we mentioned before, New Hampshire voters recently approved an amendment to the state constitution in 2018 that ensured an individual's rights to privacy from government intrusion. However, this does not necessarily protect the privacy of their data held by contracted third-party services. So this amendment seeks to stop that gap. And then, as we discussed, recent Supreme Court cases such as Carpenter, as well as United States versus Miller and Smith versus Maryland back in the 1970s, have had generally narrow rulings and have left the third-party doctrine open to interpretation. And in regards to that, a lot of state governments have begun to address the issue. Specifically in Utah, last year, 2019, they passed the Electronic Information or Data Privacy Act, which required a warrant for accessing Utah residents' private information stored with third parties. So it's an emerging issue, and the answers may not be easy, but it's starting to come to the forefront. And then with Supreme Court case law not yet caught up with the current practices, there's still a lot left open to interpretation. And essentially this amendment is aimed to provide the foundational principle that a citizen's electronic data is confidential and protected by legally enforceable contracts. New Hampshire voters should have the opportunity to decide who owns their data, regardless of where it is stored. Ultimately, it should be left up to the consumers and the companies to determine the nature of their relationship. The government can enforce the contracts if there's a dispute between a company and a consumer, but they should not dictate or interfere with those contracts. And we just believe that limited government in this regard might be the best way to address all the parties concerned with that. As we said, this is a new frontier. The issues may not be straightforward or easy, but we just want to make sure that the rights and civil liberties of all New Hampshire citizens are protected and addressed. Thank you very much.
Thank you very much, Representative Woodbury.
Thank you, Madam Chair. I'm indebted to Representative Griffin and Representative Gordon for helping me understand this a little better, I think. If I write a letter to somebody and send it by U.S. mail, the information that I having that letter in the hands of the person who receives the letter is not protected. That's the third-party doctrine in a nutshell, as I understand it. Even though I may have wished to keep it the way I used it. The use of this amendment, it seems to me, I could sort of sanitize that by, instead of writing a letter, I would simply write an email, because it then becomes part of my contract with my email. Is that what the intention is, that you can sort of sanitize the situation simply by using an electronic medium versus an old-fashioned snail mail one? Or is it more so?
I think it goes to the heart of that, just with the times, how they've evolved. Letters just aren't as popular as they used to be, and then with electronic mail just being so prevalent, this amendment would just make sure that that specific aspect is covered. And email servers and internet service providers are definitely the main consumers, or those are the main avenues that consumers will use. So I don't exactly would have the exact, I could only speculate on the exact nature of what would define some correspondence in that nature, but since it would be an electronic form of communication, which would then have the email service provider would have access to, the language in the amendment would be able to cover that. And I can follow up with you and provide you with more specifics if you would like regarding that.
Thank you, Madam Chair.
Representative Brennan's question.
Okay, so just to clarify, so I can understand myself what Representative Woodbury is saying, to follow along that analogy, if I send you an email, you are free at any time to disclose the email that I sent you, and this would not prevent that. But the internet service provider could not provide that.
Not without my permission, because I understand it. If I was the consumer willingly providing you with the email that I had.
The service provider could not provide it without me, the sender, if this passed, agreeing to it.
I could only speculate on the exact nature. I would, just looking at the language again, I'd have to look on that, but just based on what is being presented, I would say yes.
Representative Chase.
Thank you. Madam Chair, thanks for taking my question, because I am trying to figure it all out, but still confused. Is this like the issues that we've been having with, say, shootings and iPhone not giving the phone information?
That's certainly a recent area of discussion in regards to that. I know especially with the U.S. government looking into Apple, looking into that. I know there's been concerns raised on why they would do that, whether they should, because the reporting on that seems that they could just ask any third party, that organization that specializes in that, but that they're asking the manufacturer specifically. I know they have different reasons for asking that. I'm not exactly sure how that would be applied with that, and I can definitely refer to other witnesses when it comes to that, but I know it's a fine line to walk, and as thinking of the manufacturers for Apple, they have the decision to make, especially if we're marketing that our products are private, none of our consumers or our customers' information will be, without the proper procedure of a search warrant approved by a judge. As long as that due process is maintained, they're not just going to give it out to government agencies without that search warrant. So short answer is I believe that will still apply, and I wouldn't be able to give a definitive answer, but I can definitely follow up.
You follow, and I just follow up real quickly. Okay, so I understand now, so that's the manufacturer, but it would be the provider of the phone service, is what this is more about?
I could only speculate on that as well. I can look to see exactly what the parameters, who would be included with that, and I can definitely follow up.
All right, thank you.
Yes, ma'am.
Thank you.
Representative Sylvia's question.
Thank you, Madam Chair. Thank you for taking my question. As we drift into these contracts that are based in other places, in fact, I think we have one that we signed at the state level here that's a service provider in Canada, and the law is based in Canada. Would there be any protection of this amendment to the Constitution that would affect that?
With foreign providers specifically, or?
Anyone out of state.
I would believe it would. I'd have to look again at the language again, and I would have to probably defer to other witnesses when it comes to that. But the internet is very amorous, very flexible, and hard to define. And obviously, with different connections, servers can be located in a different state from where you are. So obviously, that's part of the issue. Just trying to find definitive solutions when it comes to that. And that can definitely be something that I can provide further research on, especially with foreign governments or foreign countries that they're hosting servers, as well as providing services with citizens in New Hampshire. That'll definitely be something, an ongoing part of the conversation.
I just want, you'll call on Representative first, but I neglected to ask the prime sponsor something, and that is the origin of this particular language. Did it come from Heartland? Did it come from Mercator? Where did the initial language?
So I worked with the Center for Legalization of Privacy. That's another speaker today, and we really worked on drafting the language together.
Thank you.
Yeah.
I just didn't know if we were asking you questions that could better be asked of someone else. But Representative Birch had a question for you.
Thank you, Madam Chair, and thank you for taking my questions. You mentioned Smith versus Maryland. I thought we'd talk about that for a minute. As I recall, Smith versus Maryland, a robbery victim was getting all sorts of harassing phone calls, calling police, and essentially the police put a pen register on the victim's phone and was able to trace
What's the question?
Trace that back to the maker of the calls. There was no warrant or anything. The Supreme Court held that such a procedure didn't involve any expectation of privacy. Are you suggesting that that was wrongly decided? Do you think that if somebody's making harassing phone calls to someone, that the recipient of that goes to the police, there would need to be a search warrant to protect the caller's right to privacy?
I'm not aware of enough complete details of the case to make a definitive answer with that. I know the ruling, the court concluded that there was no reasonable expectation of privacy when the government obtained a list of those phone numbers. And that just reading, just a quote here, quote, "They know that they must convey numerical information to the phone company and cannot harbor any general expectations, and the numbers they dial will remain secret." So that's, unfortunately, that's the extent of my understanding, but that was kind of the basis for what the court ruled. But unfortunately, I probably shouldn't make a definitive conclusion on that.
Thank you very much for your time. Appreciate it. The chair recognizes Jennifer Huddleston from the Mercatus Center at George Mason University.
Madam Chairwoman, my colleague has copies of my written testimony. Maybe distribute them to the committee.
Of course, if you would just give them to Representative McLean at the end of the table, he'll help you. Thank you.
Good morning, Chairwoman Smith, Vice Chairwoman Key, and distinguished members of the Judiciary Committee. My name is Jennifer Huddleston, and I am a research fellow with the Mercatus Center at George Mason University, where my research focuses on the intersection of law and technology, including issues related to data privacy and data protection. Thank you for the opportunity to provide testimony today regarding my research and its relation to the regulation of search and seizure. In this testimony, I plan to cover 3 key points. First, clarifying the requirements for government to obtain access to electronic information can be an important and appropriate role for states in protecting their citizens' civil liberties. Second, that establishing statutory requirements for access by the government to electronic information reflects both the original intentions of such protections from search and seizures and limits the disruption of innovation by preventing potential abuses while still enabling justified use of technology by law enforcement and others. And finally, the importance for policymakers in avoiding potential spillover effects and unintended consequences beyond the search and seizure context when it comes to the government's use of widely available technology and the future of innovation in general.
If I could just interrupt for a moment, I see where you are after point number 3. I assure you that not only can everybody on the committee read, but we will read the testimony. So if you could summarize
Yes, ma'am.
and help us understand the key points, that would make it easier for us to understand the written
Yes, ma'am,
testimony.
I will.
Thank you.
We provide educational information, so we neither support nor.
Thank you. Yes, please
So
do.
to begin with, these type of bills are distinct from the type of data privacy bills we're seeing out of states like California, which are broad-based consumer privacy bills that are largely affecting the interaction between a consumer and a company. So you may have heard about the California Consumer Privacy Act, or CCPA. There are a lot of concerns about the potential constitutionality of bills like that, particularly if related to the Dormant Commerce Clause. When consumer is defined very broadly and there are broad data privacy regulation at a state level, there's quite likely that it could spill over and have effects on a more national level that may be unintended or may not align with other states' preferences. Additionally, those bills raise other constitutional concerns, such as First Amendment considerations, and also the potential to conflict with the system of law. In contrast, bills regarding the access to third-party information and electronic search and seizure are more of an interstate issue. It's the government restraining its own ability and to access their current information, and it's also a case where states are actually having the opportunity to act as a leader. They're extending what the Supreme Court started in Carpenter by identifying that some technological changes may have raised questions about the third-party doctrine. In the past, when you handed a bank teller a piece of paper, or you went into a phone booth and dialed a number, you were aware that you were sharing that information with a third party. Today, a lot of times the data that may have been able to be accessed under the third-party doctrine is much more passive. There isn't that same understanding. So last legislative session, Utah, looking at Carpenter and looking at kind of the way technology was evolving, has the first of its kind law that established warrant level protection for all electronic data. In some ways, this is expanding on the way the federal government has been heading, but also reflecting the traditional trajectory. This bill would have a similar impact on the potential for protecting individual civil liberties, but it still allows law enforcement and government to get that information if they go through the appropriate steps, such as obtaining a warrant. Such bills are likely to become increasingly important in an increasingly connected market. So, in a flexible approach that addresses not only the concerns regarding our current data situation, things like email or cell phones or some of the other examples like the cloud that have even been brought up today. They also can impact things like driver that would be able to transmit location data, or IoT devices, or many of us who are already wearing smartwatches, Fitbits, Apple Watches, and the information that's collected there on an incidental account. It also, though, however, enables law enforcement to access that information when it is valuable. It still allows the obtaining of a warrant. And so there are cases that we have seen where technology helps law enforcement either eliminate potentially someone who's wrongly accused or provide detailed information such as a time of death. It also, there are cases where this data would be useful for under a search warrant, even if it is something like cell phone location information. So, for example, in the Carpenter case, the court didn't say that law enforcement or government could never obtain cell site location information. It merely said that that information was subject to Fourth Amendment protection. Rather than listing every technology that currently exists, a more flexible approach that addresses the underlying principles behind why the third-party doctrine might not make sense in certain situations will allow the law to adapt to new technologies that we might not be able to even predict. Now, at the same time, it's important to think about the potential for unintended consequences beyond just the scope of search and seizure. Certainly, we don't want a situation where government or law enforcement is unfairly handicapped and unable to use new technologies that could be incredibly useful for, say, finding a missing child, or for other positive benevolent purposes, but at the same time, we want to ensure that there are appropriate balances on maintaining citizens' civil liberties. Again, addressing the underlying principles there, as well as looking at narrowly tailoring specific use cases if there is a need for additional regulation of preventing law enforcement or government to use certain technologies. This has become a debate not only in the access to electronic information, but on a variety of technologies such as GPS locations and facial recognition. And it's certainly likely to become an increasing conversation as we see a more connected future. Also, the language here matters, and there are a lot of questions about how this could potentially spill over. So for example, the concept of owning your data may sound wonderful in a law enforcement context. And it's also one of those things that oftentimes, particularly for those of us that are attorneys, is an easy concept to think we grasp. But data doesn't follow the traditional rules of property. It rarely is owned or created or has that bundle of sticks and rights with one single individual. So we should be cautious about saying things like owning the data, even in other contexts, so that that doesn't spill over and have unintended consequences on the future of innovation and some potentially really beneficial uses of data. Data privacy is a multifaceted issue. Oftentimes we hear about it in the context of data breaches or consumer rights, but this is another example of where the government and policymakers need to carefully consider how technology may be evolving and whether or not the law as it currently is sufficient or if it needs to evolve along with technology. By establishing a framework for government access to electronic data, as with other issues in technology, it is an important opportunity for states to act as a leader and provide greater clarity to consumers, innovators, and government actors on this emerging issue and appropriately balance civil liberties as well as the future of technology. I thank you for your time and I welcome your questions.
Thank you very much for your substantive testimony. I believe Representative Griffin had a question?
I did, but I'm wondering what, I'm gonna ask you and maybe another party. Thank you very much for your testimony and your knowledge of the issue. On the first page of the written version of the testimony that you're giving us, you pointed out that part of dealing with this is establishing statutory requirements for access. The bill in front of us, while being enacted in the statutory process, is actually a constitutional amendment. I understand from the sponsor of the bill who worked more closely with another organization in drafting this. Do you have a position as to this being a constitutional amendment as compared to statutory?
No, ma'am, I don't.
Thank you.
Thank you for that question. Are there any other questions? Not seeing any again, I thank you for taking the time to come here and to share your deep knowledge with us. The chair recognizes Amy, is it P or Pi?
P.
Amy Peacock, coming from California, Orange, California, the Center for the Legalization of Privacy. Thank you, and I believe you have distributed. You distributed your testimony.
Written testimony. And with your permission, I might read a little bit of it and then skip over some of it. It's quite short. So
Terrific. Thank you very much.
Take any questions as well. Thank you, Chairwoman Smith and the committee for allowing me to come and speak here today. I'm from California, but I actually lived in Nashua for 3 years.
And why did you ever leave?
I was a child. I didn't have a choice. So I just plead
well, we believe in choice in all times in New Hampshire, so you can
that's
back
very
anytime.
good, because that's what I'm about here, is I'm about giving New Hampshire citizens as much choice as possible. I like to think that my 5th grade teacher at Maine Dunstable Elementary School in Nashua, his name was Mr. Levesque, and he was very forward-looking. I don't want to tell you how forward, because then I'd be dating myself, but he allowed the girls who wanted to play football with the boys and him during recess to join in. And so I was one of 2 that got that experience repeatedly and had an effect on me. So I like to think that he's a small part of why I'm here today, and that would keep me happy about it, but didn't want to say we'll see. So as I said, thank you for giving me this opportunity. As I'm going to explain, CACR15 presents an opportunity for New Hampshire to lead the way in restoring crucial constitutional protections for individuals, while, importantly, at the same time, preserving government's ability to engage in legitimate criminal investigations. In my view, a pillar of a free society and limited government is that law enforcement must obtain a warrant based on both probable cause and particularized suspicion before accessing citizens' private data. And I don't think it's a partisan issue at all. I think both sides could agree on this. And yet, we've been deprived of this basic protection since the 1970s. Why? This is because the United States Supreme Court unjustifiably expanded this third-party doctrine that we've been talking about. The doctrine now says that once you share information with a third party, and this is not just an electronic data issue, this is any kind of third party. Once you share information with a third party, you no longer have what's called a reasonable expectation of privacy in that data, and consequently that information no longer enjoys the Fourth Amendment's warrant requirement protection. That's the way the doctrine is currently interpreted. Now, in a couple paragraphs here, I talk about the history of this. The third-party doctrine did not just spring up in the 1970s, and unfortunately, in some of the opinions in the Carpenter case from 2018, even justices talk about the origin of this doctrine in the 1970s. It did not come to be in the 1970s. It had been in effect for decades, but for decades, that doctrine had only been in what's called the secret agent cases. And the secret agent cases involved what the representatives were discussing with Representative Yokela up here, involved illegal contracts, okay? And in an illegal contract, it's not enforceable. So if you have your agreement about the Coca-Cola formula that you stole and you're gonna go make it some money off of the secret formula, that contract is not enforceable. Neither is any side agreement that you have to keep out all the information that you share secret. So if you have an unenforceable contract, it makes sense that if you share information as part of that contract, the government can obtain it without a warrant. The government is not violating anybody's rights. And if anybody on the committee is familiar with the history of the Fourth Amendment and the way it's been construed at the federal level at least, it used to be that they would look at trespass as an indication of whether there had been a violation of the citizens' rights under the Fourth Amendment. If there had been an unreasonable search and seizure, law enforcement had committed a trespass. Today we don't really talk about trespass. I agree with Ms. Huddleston about the fact that speaking of data as being owned is not necessarily helpful. But what we see today is that a lot of our information, a lot of the private information about us is shared in the context of a contract that I have with Facebook, with my bank, with my internet service provider, my cell phone service provider, my grocery store. You go to the grocery store and you get the little, those here, right, the little membership cards they have in California, the grocery store. They collect all kinds of information about you and your shopping habits that way. So we are constantly sharing information with third parties, and so what we're looking at now is, whereas our privacy used to be primarily protected through property, now it is primarily protected through contract. And because of this detour that the Supreme Court took in the 1970s, those contracts are not being enforced so as to protect our privacy. We still have privacy in our homes, but I don't think the Supreme Court realized the ramifications of transporting the third-party doctrine into the ordinary contractual situation. We are not criminals. We have not gone to Coca-Cola and stolen the secret formula and engaged in some scheme to go ahead and make some money off of it. All we do is we go to Facebook and we want to share our cat pictures and our cute kid pictures. Or we want to just have cell phone service and drive around and be able to actually know where we're going because we've all become dependent on the GPS device, etc., right? We are just ordinary citizens trying to take advantage of all the wonderful goods and services, some of them electronic, some of them not, that enrich our lives. And we don't believe that we should have to give up Fourth Amendment warrant protection for private things about us in order to do that. That's really what this is about, because today privacy is protected as much, if not more, by a contractual arrangement than it has been historically through property rights. And so this is just really restoring the sort of expectation of privacy that citizens have via the language that is necessary to do this. Now with CACR 15, individuals will be permitted to share information for limited purpose while still enjoying robust warrant requirement protection. It will not burden private individuals or businesses. It is a limitation on law enforcement only. So, sir, when you spoke about Canada, the limitation is not on a Canadian service provider. It's on law enforcement. But law enforcement may not go and obtain that or demand it unless they can present a warrant. So it would, any provider, service provider, provider of goods who was contracting with a New Hampshire citizen, and you had New Hampshire law enforcement trying to go to that provider to get the information, they would have to provide a warrant. They can still get the information from the provider, but they have to provide a warrant under CACR. Now, at the same time, the precise language that we have in the provision, which Representative Drukilla and I worked on, it excludes data shared as part of an illegal contractual arrangement. Now, that is not going to enjoy warrant protection, okay? So the original impetus for the third-party doctrine, I think, was well-intentioned. It said, if you're engaged in a criminal scheme, the contract that you are making with your cohorts is not enforceable. And that includes any side agreements to keep the information private. I believe that was the actual rationale for the third-party doctrine, although it wasn't stated explicitly. It is rooted in our common law. So accordingly, CACR 15 is worded to provide the increased protection only for legal contracts of ordinary citizens. Again, it is worded so as to correct this detour that the Supreme Court took in the 1970s in Smith and Miller. And so, yes, I would say Smith was wrongly decided. Not because I think that people should be able to harass others with phone calls or what the bad guy was doing in that case, right? But that the contract that you have with the telephone company is not itself an illegal contract. And so what law enforcement should have to do is provide a warrant based on probable cause and particular suspicion, which they may well have been able to do in the Smith case. If you look at the facts of Smith, I think they may have been able to get a warrant, but they just didn't bother to. A lot of these cases, just because they didn't get the proper warrant that they needed. So that's all we're asking, is that police get a warrant in order to induce what would otherwise be a breach of contract with a customer in a perfectly legal contractual arrangement. So what will it do? It will reinstate CACR 15. It will reinstate the bright line that I believe the Supreme Court erased in the 1970s. And this is the line between criminals who are making illegal contracts, which should not be enforced, and contracts that are made by law-abiding citizens, which should be. So CACR 15 will actually be unlike what Utah or anybody else has been doing on this issue. You have an opportunity here to be a leader and provide New Hampshire citizens first with protection that has, should have been here all along. So I'm happy to answer any questions.
Thank you very much. Representative Griffin.
Thank you, Madam Chair. Thank you for taking my question. You just pointed out a distinction as to this bill in Utah and California. Utah and California, they are statutory enactments of this protection as compared to this, which is...
Well, California hasn't done anything like this yet. The California Consumer Protection Privacy is different from this. That is actually a restriction on what corporations may do with your... So
understood, but they're both statutory provisions as compared to
Okay,
constitution.
Mm-hmm.
And I think we heard earlier that one of the glories of new constitutional provisions is that we get to have lots of court cases to decide exactly what it means, right? So
Yes.
could it be thought that perhaps Utah took the more logical approach to this to provide specific guidance as to what was protected and not protected as compared to this conundrum where as a group of fairly learned persons we can't even agree on what provided meant?
Well, I think we could talk about what provided meant, and I think provided and shared are quite similar, and I wanna ask what
I'm sorry, I don't mean to.
Sure.
To
What the
get
representative
sidetracked.
thinks for sure. But I actually think the situation is the opposite of what you're worried about. Because I think that Utah, in getting rid of the third-party doctrine entirely, in essence, that's what they've done. The only thing that they've done is they've allowed an exception for imminent danger. I think that they are the ones who are going to have the court cases clarifying their language. Because what if they have a case involving an illegal scheme like we're talking about? You steal the Coca-Cola formula. The situation, the hypothetical that I have is a bunch of scumbags start a Telegram group for sharing child pornography. And they have this deal, I've got this great child pornography, and I'm gonna share it with you as long as you share all the best stuff that you've got with me. These are some bad guys. But suppose a government agent gets himself invited to this Telegram group and poses as a scumbag and, gets information about these people and then reveals it to law enforcement that there's never been any warrant. What is Utah gonna do with that case, right? Because there's not an imminent threat to anybody, so is it gonna fall under the imminent exigent circumstances exception that they're gonna allow? I would say it is a much better, scenario if we are clear that we're gonna say that arrangement that those scumbags have made in their Telegram group is not a legally enforceable contract because they're engaged in illegal conduct. It's for an illegal purpose. And so I think by wording it this way, although I understand there's some questions about why exactly this language, and the third-party doctrine itself makes people's eyes glaze over. This is very precise language geared to permit and protect, permit choice to, and to protect the rights of law-abiding citizens, while at the same time allowing law enforcement to infiltrate criminal schemes, put secret agents in there, go after scumbags. In the electronic version of this testimony, which I think has been emailed to all of you, I've got a hyperlink to a law review article in which I explain the rationale behind drawing that distinction between illegal contracts and illegal contracts as the basis for where the Supreme Court went wrong with the third-party doctrine. And that might be clarifying as well. But I actually think that you will have less problems interpreting the language in this scenario than with Utah, and even Arizona arguably in their litigation has attempted to blanket, get rid of the third-party doctrine entirely. What are they going to do with these illegal contract situations where there's not an imminent risk of bodily or other significant harm?
Thank you. Thank you. Are there any other questions?
Yeah.
Representative Wilbur has a question.
So I thought, maybe I just don't know what's going on. So the question I have is the same question was asked earlier. Why is this a constitutional amendment as opposed to statute law?
I think that a constitutional amendment is the only way to restore a constitutional protection that has been withdrawn from citizens, like I said, since the 1970s. If you were going to either offer some sort of a clarification to another constitutional provision that was only legislative, then the next batch of legislators could change their mind and offer a different clarification, then suddenly this crucial protection would be gone. Again, I believe a pillar of a free society and limited government is that law enforcement needs to get a warrant. There needs to be probable cause and particularized suspicion before you allow access, government access, to the private data of citizens. And the only way to guarantee that as firmly as possible, right? Because even a constitutional amendment is not sacrosanct forever. It can be changed later, but it's a lot harder to change. It is the best that we as human beings providing government to protect citizens' rights can do, the constitutional amendment. So as strong protection as possible that you could provide in restoring this for your citizens, I think is the best way to go.
Thank you very much. Representative Gordon has a question.
Again, get back to the language. Part of it says legally enforceable contract that is to be used only for a limited purpose. Is that is to be used only for a limited purpose apply to the information or to
Yes,
the content?
yes. And so if we went back to grammar school
That's
and
not
diagrammed
grammatically
that, we would know that the use for limited purpose is going to apply to information. Yes.
That's not grammatically correct as it's written.
You think it's not. So
So
you think we need to make modifications?
I think it modifies the contract.
I believe that you have two modifying clauses of information. And so one of them is that it's provided as part of a legally enforceable contract, and then the second modification is that it's to be used only for a limited purpose. But
The
I think,
information is to be used only for.
yes, and otherwise kept confidential.
So to follow up, Madam Chair, so to be correct, would that not say including information that is to be used only for a limited purpose, provided as part of a legally enforceable contract?
So you would want to displace the clause or you put a comma in you think it's unclear the way it is because of the.
Well, I guess I'm just going back to English class, it's saying, the sentence structure is grammatically correct.
Thank you for that. I never diagrammed a sentence in my life. I was a product of progressive education. Are there any other questions?
Yeah.
Yes, Representative Gordon.
So, we would modify the New Hampshire Constitution, and under New Hampshire law, under general any law, the state is entitled to have a constitution that provides more protection than the federal constitution. So, in federal cases, how will that apply to federal cases? This would affect New Hampshire law enforcement.
Yes.
How would it affect federal law enforcement dealing with matters?
Yeah, and you're not going to be able to restrict the conduct of federal law enforcement agents. You will be able to restrict, of course, the New Hampshire law enforcement agents, but I do think that it will also set an important precedent such that combined with what we've seen in Carpenter, where the Supreme Court is already trying to put a limitation on the third-party doctrine, they're moving in that direction. I think that at some point we're going to see more and more states do this, and eventually there will be restrictions on the federal level as well. At least that's my hope.
Thank you very much. Are there any other questions? If not, again, thank you for taking the time to be here. I appreciate it very much. The chair recognizes the final speaker, Dan Itzy, who is going to be unbelievably brief since this committee has a 1 o'clock.
Where are you speaking again? But being that as it may, one, I want to compliment the drafters. While I understand Representative Gordon's position about the juxtaposition of limited purpose, I think he may well be right. The fact that the language is so brief and general, I think is great, opposed to the amendment to Part 1, Article 8 last year, which I thought was overly verbose. To Representative Gordon's question regarding the letter from the U.S. Postal Service and the recipient, the issue is not the sender or the recipient. The issue is the U.S. Postal Service, which is in between where the information lies for a time. Now, in our current situation, information in the hands of the U.S. Postal Service is in fact protected. Furthermore, a better comparison would be if you sent your letter via UPS. But then imagine that letter that you sent by UPS by their nature makes a copy of it and keeps that copy. And we're talking about the access to that copy that UPS keeps. And they said they're going to keep it confidential, but right now it can be obtained by subpoena and not by a warrant for a particular purpose on presumption of the crime. And that's the real issue where we are. The problem is that now all the things that we used to send as hard copy and didn't exist somewhere out there are now subject to being obtained by the government, not through the sender or the receiver, but out in the ether, if you will. As to Representative Chase's question, no, this would not protect the shooter, and I think it would give greater clarity as to what Apple was obligated to do, because pursuant to a search warrant, Apple could no longer hide behind it, because we say that information can be obtained by a search warrant. So it gives very positive direction. I think it absolutely ought to be a constitutional amendment, because we are talking about personal, private information and how an individual's privacy in regard to that is relatively young. And it provides a framework in which you will all eventually write statutes that say how the government goes about getting it. On a more general level, the Constitution of the United States has, in Part 1, Article 1, Section 10, a prohibition on the states. And it says, among other things, that no state shall pass any law impairing the obligation of contracts. So you can't pass a law that changes a standing contract. This extends that prohibition not only upon the legislature, but on the executive and judicial branches. You can't just go out, they will not be able to go out and willy-nilly invade the presumed privacy of an established legal contract. So it's extending that idea that the state government can't impair existing legal contracts.
Thank you.
And I want to just show you one thing. See, this is an antiquated cell phone. I keep it because it is the last cell phone that I can update my contacts between my computer and my cell phone without putting the data to the cloud. And that's why I go to great extent. This phone protects my privacy. I do not put my pictures nor any of your addresses and your connection to me into the cloud. I keep it only between my phone and my computer.
And your car, thank you very much. Any other questions? If not, thank you very much. This closes the hearing on CACR 15. Are those people in the room here for the next